So let's discuss about Section 122 of the Indian Evidence Act, also known as Section 128 of the Bharatiya Sakshya Adhiniyam, that says communication made during marriage. But before that, I request you all to kindly take your bare acts and keep on marking the important words as I explain them to you. So this section says that no person who is or has been married, कोई भी ऐसा पर्सन जो अभी मैरिड है या मैरिड रह चुका है, shall be compelled to disclose any communication made to him during marriage by any person to whom he is or has been married. So let me explain this to you. For instance, there is a married couple, say A is the husband and B is the wife, and A says something to B, and in response to that B also says something to A. It can be any communication, be it a normal one or a heated argument. What Section 122 is saying that neither A nor B can be compelled in the court of law to use that particular communication as an evidence against each other. This section is actually in the nature of protection, and that is the reason it comes under the head of the privileged communication. And that is why neither A nor B, you cannot compel them to give evidence against each other with respect to that communication that has happened between them. This section further says that unless the person who made it or his representatives in interest consents to it, which means या तो A ने उस चीज की कंसेंट दे दी कि ठीक है अब आप कोर्ट ऑफ लॉ में इसको यूज कर सकते हैं, या फिर उसके रिप्रेजेंटेटिव्स इन इंटरेस्ट ने उस चीज की कंसेंट दी है. Otherwise, you cannot use that communication. Section 122 completely bars that. Now, there are two exceptions that are being given in this section. It says that except in the suits between married person or proceedings in which one married person is prosecuted for any crime committed against the other. Only in cases of a civil suit, या तो मैरिड कपल के बीच में कोई सिविल सूट चल रहा हो या कोई प्रोसीडिंग ऐसी जिसमें एक पर्सन को दूसरे के अगेंस्ट प्रोसिक्यूट किया जा रहा है, only in these two cases it will be allowed. Otherwise, Section 122 completely bars that. Now the next question that comes is this section applicable to third party also? So for instance, there is a married couple and they're in their room and there is some communication that is happening between them, and C is the father-in-law of A. He's standing outside the room and he hears that, and next day in the court of law he says that जज साहब मैंने तो इनको ये बात करते हुए सुना था और इन्होंने तो ऐसा कहा था. तो क्या आप सी को भी बार कर सकते हैं कि नहीं ये तो अलाउड नहीं है क्योंकि इन दोनों के बीच की बात है? So the answer to this is no. C cannot be barred. C will be allowed to use that evidence in the court because the protection is given only to married people and not to any third person, as the section clearly says that a person who is or has been married. This section is not applicable on third person. This bar is applicable lifelong and cannot be dissolved even after the marriage is broken. Even after the divorce has happened, you cannot use that communication that had happened during their marriage. So this was all about Section 122. This is a very important section in the Indian Evidence Act, and I hope this was helpful to you. If you still have any doubts, please comment down below. I'll be happy to help. And all the best.